Welcome to the All Rise podcast, Sunday Scaries. I'm your host, Christine, a civil litigator and personal mentor. Every Sunday, we'll tackle those dreaded Sunday Scaries together to demystify the practice of law and provide you with actionable tips and guidance to face your week ahead. So grab a cup of coffee, take a deep breath, and join me while we turn those Sunday Scaries into stepping stones towards your success. Let's get started. Welcome back to the All Rise podcast, Sunday Scaries. I'm your host, Christine Barker. Today is part 2 in our 4-part series of case handling start to finish. Today we're going to be talking about creating and implementing discovery plans. So whether you're on the plaintiff side or the defense side, before you can start litigating, you got to know what your case is about. For the plaintiffs, this means that you're going to be developing a complaint. What causes of action are you going to try and advance based upon the underlying facts? For the defense, this is going to be a little bit easier because a plaintiff will have filed the complaint already. You are going to have to assess those causes of action and then determine what affirmative defenses you're going to try and advance on behalf of your client. Your discovery plan is essentially a roadmap for your case, your destination, resolution, whether that's through trial or it's through settlement. But your discovery plan is going to help you get there. The best way to start planning out this roadmap is to actually go to the end. I was amazed my first time that I went through trial that, and I didn't really have a clear direction because I didn't have a discovery plan. It wasn't until I got all the way through trial and through verdict that I realized, oh, I need the jury instructions. This is the stuff that I'm going to have to prove or disprove at the time of trial. So I might as well start there. So pull the jury instructions. That's going to give you all of the elements that you're going to have to either prove or disprove through the evidence that you're going to gather in your discovery plan. Once you have the jury instructions, and again, I put this all in a document, title it Discovery Plan. I've got my causes of action. I have each of the elements listed out based upon the jury instructions. Now I'm going to have to start organizing my facts. You're going to have to identify the necessary facts to establish each element of each legal theory. What facts are you going to need to establish a claim and or a defense? Figuring out the facts you have, the first thing you're going to need to do is figure out the facts you already have. Like we talked last week, you're going to interview your client. And your client is going to tell their story to you. And they're going to give you all of those underlying facts. You're going to take those facts and start plugging them in to each one of the elements. This is going to assist you in identifying any holes that you might have, holes that you are then going to use discovery tools to fill in the blanks. I would also suggest doing a chronology. Again, this helps to identify where there's holes in the story, and you can then use your discovery plan to start filling in those blanks. As an associate, it is very important that you are identifying both the good and the bad facts. Bad facts cannot be ignored. There is nothing worse than getting blindsided at trial by a bad fact that you could have discovered during your discovery plan. As the associate, it's not your fault that there's a bad fact. It's not your fault that a witness could potentially go sideways. It is your responsibility, though, to alert those bad facts or those potential difficult witnesses to your partner. That way, together, you can assess early on what you're going to do with those bad facts or that potential difficult witness, and help to then move your roadmap towards resolution. Next, you're going to identify your witness. I like to have a separate document where I start listing out all of the potential witnesses. This can be an exhaustive list. You want to make sure that this is as inclusive as possible. I also put things in there like contact information, and maybe a summary of like a paragraph or two of essentially what they would testify to if they were called at trial or during a deposition. You don't have to call all of these witnesses. You may not need all of them, but it is important to kind of do a who's who of your case so you know potentially who could be called. And again, you're not blindsided at trial by some surprised witness. As the litigation continues, more witnesses might be identified during written discovery or in depositions. Again, just keep adding to that list. So to recap, we've got 2 things going on right now. We've got our discovery plan with each of our causes of action, all of the elements, and then we have key facts that are being inserted into that discovery plan based upon the information that you're gathering. We also have a witness list.
We've got each witness identified, contact information, summary of what their potential testimony could be. I also like to throw in there whether I think they're going to be a good witness or a bad witness. Now you'll want to identify documents. I like to, again, separate this into two categories: documents I have and documents I need. So documents I have are things that my client has already provided to me. Documents I need are things that are going to go into my discovery plan, and these are things that I'm going to need to ask for or seek out in discovery. Again, I like to keep a running list of these documents, key documents. I call them hot docs. These are documents that I'm potentially going to need to use at trial. And when you're creating these things as you're going along, that witness list is going to turn into your trial witness list. That document list is going to turn into your exhibit list at trial. We're building a foundation here that you're going to continue to build as this case goes along. It makes it so much easier if you're doing it as you go along, as opposed to trying to create all of this at the end while you're preparing for trial. The documentary evidence that you need to obtain depends on the type of case that you're going to have. So, for example, you might want things like witness statements or incident reports, traffic collision reports, medical records if it's an injury, a defect list, a cost of repair if there's property damage. Those are all kind of documents you're going to need to be kind of on the lookout for. Now that we've identified the witnesses that we have, the documents we have, we also need to make sure that we're being on the lookout for witnesses we're going to need and documents we're going to need. There are different sources available to you for you to go now gather all of the evidence that you need so that you can continue plugging that information into your discovery plan. So, two sources: informal sources, formal sources. Your informal sources are going to be things like your client. Call up your client. That initial client interview at the very beginning of the case is essential for you to gather up information from your client. Let them tell you their story. They've lived the facts of this case in real life time. You are now extracting that information from them. Other sources available to you informally are things like public records, social media. I love to run a social media on any witness, on any case that I have. It's amazing what people still put out there on social media. Internet searches, and then obviously you've got your Lexis searches where you can do asset searches and background checks. So all of those, like I said, informal sources. Notice in our discovery plan so far, we actually haven't propounded any discovery yet. There is a wealth of information available to you as the associate before you even propound one interrogatory. So don't overlook all of that preparation stuff, because you can get a lot of information about your case before you've even propounded one interrogatory. But you are likely going to have to utilize some of these formal tools in your discovery tool chest. So these are going to be things like document request, interrogatories, request for admissions, subpoenas, both for deposition and for third-party documents, depositions of witnesses, expert depositions, visual inspections, destructive testing, or maybe an independent medical examination if you're dealing with an injury. Things to consider as well are budgetary restrictions. So things like interrogatories, requests for productions, and subpoenas are fairly inexpensive ways to do formal discovery to get information. Things like depositions are a little more expensive. You're going to have the attorney time to prepare, take the deposition or defend a deposition. You're going to have to pay a court reporter and likely purchase a transcript. So those are more expensive ways of gathering information. A lot of times associates want to jump right into depositions, but it's really important that you utilize more economic ways of gathering information. And then because during the process, you're discovering more things about your case. If you uncover a really bad fact for you, the smoking gun, if you will, during written discovery, why would you take a deposition and have your client go on record highlighting that bad fact for you? That might be a time for you to sit down with your partner and say, hey, we just came across this really bad document or a witness who's going to just derail our entire case. Maybe we should start looking at resolution options. Timing is very, very important. So like in creating your discovery plan, you're going to start at the end with the jury instructions. So too is the court. Everything's going to be triggered by that trial date. The trial date is going to let you know when discovery cuts off, motions cut off. And if you're going to bring any dispositive motions, like a motion for summary judgment or adjudication, there's also a lot of lead time that's required for that. So you're going to want to build your discovery plan backwards. Start at your discovery cutoff date. Factor in how much time you're going to need if you need to do any law in motion. Factor in how much time you're going to need to do any meet and confers and maybe informal discovery conferences if your discovery responses aren't sufficient. Factor in the time that you're going to need to propound the discovery and for them to respond. See how we're working backwards? This then is going to tell you when you need to start propounding discovery. All of this working backwards really helps to create that roadmap, but then also prevents you from just cramming everything at the end and kind of missing steps because you're trying to hurry up and get everything done. And then finally, resolution options. We're going to talk more about this in part 3 next week when we're talking about settlements, mediations, and mediators. But during the course of your discovery, there are going to be plenty of opportunities for you to try and resolve a case. Your client is not in the business of wanting to litigate. You're the litigator. This is your business. Their business is likely something else, and they just got caught and stuck in a lawsuit. So they want to get this lawsuit wrapped up and resolved as quickly as possible. Sometimes that means trial, but a lot of the time, 97% of the time in civil cases, that means resolution. Throughout the course of your discovery, there are going to be lots of opportunities for resolution to take place. So again, we'll talk about that more next week in part 3. I hope this was helpful for you in creating your own roadmap, your discovery plan for your next case. We'll see you soon. Have a great Sunday.